Today on Everyday Injustice, we bring back Alexandra Cock, who has been working for a number of years on a case that's very dear to my heart, the Chief Douglas Stankewitz case. We covered the habeas hearings in 2024. I can't believe that was a year ago. And unfortunately, by the end of the year, the judge had denied it. And so now they are trying to work to free this guy who has, and I think this is the best way to frame it. Like, he went to prison when I was 5 years old, and I'm now over 50. That about says it all, right?
Yeah, it sure does. How it is that we have a system where we're locking people up for decade after decade, uh, for what good purpose, you know? So yeah, he's been down for 47 years now.
So try to help us kind of understand, like, for those who aren't as familiar as I am, what were the main issues in the habeas, and why did Judge Harold deny it?
Well, there were many issues in the habeas. So it's a little, the original habeas petition was like 219 pages long. So
Well,
there's
we'll just
many
go
issues.
page by page on it. Nah, just kidding.
No, I don't think we don't want people to fall asleep. So no, we won't do that. Um, but the main issues were the fact that the gun and holster were in the possession of law enforcement, based on what our experts said, starting 5 years before the murder. And they have no explanation for that. So that's one thing. Is our position is he didn't do the shooting, he didn't have the gun. Another main issue, is that according to our expert, the testimony that they had at the trial saying that, the shooter was taller, that the trajectory, that fit with the trajectory of the bullet, and that's just not true, because the trajectory of the bullet was an upward trajectory. So that meant someone shorter, according to our experts, had to do the shooting. Um, and there's also, what got me into this case in the first place, which is that he tested negative for gunshot residue. And, when I first saw that in the paperwork, I thought, well, how do you convict someone of murdering someone using a gun, if there's no trace of gunshot residue? But then the overarching issue, which, and I haven't even touched on prosecutorial misconduct, the fact that they lost over 50 pieces of evidence. But that's not bad faith, you know. Um, and that at the evidentiary hearing, several of the county employees got up and lied on the stand, and at least one of them, certainly seems committed perjury. So then the overarching thing is the fact that Chief's lawyer at the second trial just did not do his job at all. And nonetheless, Judge Harrell said, basically that didn't matter. Um, and and the truth is that Judge Harrell is part of the Fresno establishment, and that the way he was able to deny the habeas was by misrepresenting the testimony, by glossing over things that were important, and by saying other things were not important that were. So, I don't know, once a DA, always a DA. He did the DA's job for her. She never contested anything at the evidentiary hearing. They did not bring any witnesses or any evidence. Um, so, when you have a setup like that, trying to win a habeas decades later when almost everybody is dead is very, very difficult. And in fact, we lost one witness in the week or two before the evidentiary hearing. And we had asked the judge over a year before to basically take his deposition because he was old. All these people are old. And the judge said, well, no, because you didn't prove he had a medical condition. Well, that isn't what the statute says. The statute says over age 65. So anyway, it's one stumbling block after another. So
And you guys knew this going in, because I remember talking to you that, you were wondering, how fair the judge could be, and you were kind of hopeful during the habeas that he seemed more reasonable, but in the end he was what he was.
yeah, no, I mean, I felt like it was a total Jekyll and Hyde situation. I mean, he made it seem as though he was actually interested in what we were presenting, and he gave us all these opportunities to provide him with complete information and so on and so forth, but it was all just a ruse. It was all just ongoing cover up.
So now what, I guess, is the question that we're here to talk about.
So because we had optimism about the habeas, and the truth is, if we were before like some other judge in another county, we would have won it. I mean, because there are just so many reasons, that it should have been granted. So the legal team made the choice to um, have the habeas go first and then resentencing, because in 2022, the Fifth District Court of Appeal issued a decision stating that Chief was entitled to resentencing. And so that has been before the court, all this time, the same time while the habeas was proceeding. So now the habeas is done and we have been preparing for resentencing. At present, resentencing is set for May 1st. And I don't know whether that's going to hold or not, because in the meanwhile, we have filed 2 Racial Justice Act motions, which are on the calendar for April 10th. But again, I don't know whether that's going to stick either, because we haven't heard anything from the DA on those motions yet. So we're pursuing those. Do you want me to tell you a little bit more about the Racial Justice Act motions?
Yeah, those are interesting too. Let's start with resentencing, and then we'll go into
Okay.
the Racial Justice Act. So,
Okay.
I mean, I've seen a lot of resentencing. It's usually a fairly low bar. But do you think you can hurdle it in Fresno?
So resentencing. So basically the Fifth District said that he's entitled to full resentencing, meaning that the judge is supposed to look at every sentence imposed, which in this case means the sentence for kidnap, for robbery, for murder, as well as gun enhancements. So that's what we have been preparing for. Now, the Fifth District also said that he's entitled to a lesser sentence. And, the last sentence that he got, which was in 2019, was life without the possibility of parole. So according to them, according to the Fifth District, he should get better than life without, which would be at least life with.
Right.
Now, the DA is still pushing for life without, which, truthfully is enough for my hair to catch on fire. I
Well, yeah,
mean,
I mean, we're talking about a guy who's approaching 70, who's been
yeah,
since I was 5,
yeah,
and
no,
he's harmless at this point, even if you
yeah,
believe he did all that stuff.
yeah, yeah, no. And I mean, truthfully, I know of only a handful of people who say he should still be in, and they all come from Fresno. So, I mean, that's the truth, because everybody else is like, seriously, this guy is still in, you got to be kidding me. So theoretically, he's entitled to at least life with, and if the judge gave him life with, then he would be eligible for a parole hearing right away based on elderly parole and youthful offender. Because he's got, both ends of that spectrum. And we also made an argument for time served. And, all the lawyers who do this kind of work say, well, that's not I'll just say a legitimate argument, because there's no statute that says that he would be entitled to that. No sentencing statute. However, I've managed to pull together the argument, which is based on the Eighth Amendment, which says any additional time is cruel and unusual punishment. And there is a basis for that of it here, based on at least one case in the California Supreme Court where they said, no, there just comes a time when, on a case by case basis, you have to look at it and say, sentencing this person to more time is cruel or unusual. In California, it's a little different, cruel or unusual. So anyway, we that's one of the arguments in our sentencing memo. So, not saying that we expected the judge would do it, but at least we have it there, and it might turn out to be an appealable issue depending on what happens. So
You would say realistically that the most likely path here would be resentencing to life, then he has to go before a parole board, and then there's a pretty good case for the parole board to grant him parole at this point.
yes, his main stumbling block is going to be that he says he didn't do it. And,
Right.
the parole board wants to hear from people saying, I did it, I'm sorry I did it, and all that,
But I've read
so.
enough of this now that it seems like they're now starting to understand a little bit that there are legitimate innocence claims, and so that's not proven to be as much of a barrier as it might have been like 10 years ago.
Yeah, no, I agree. And I know of at least one person who basically presented their case to the parole board, and that's how they got out.
Yeah.
So we, of course, as we have with everything else all the way along, we will build the strongest case we can in terms of going to the parole to present evidence and information to the parole board.
Right. So tell us a bit about the racial justice case.
Well, we filed two motions for that. One is called a D motion because it's for discovery, meaning that we're asking for data from the Fresno District Attorney. And because what we would be looking at is, was Chief charged more harshly because he's Native American than other races were. We built the case as best we could for good cause, because you have to show good cause to the court in order for them to consider giving you discovery. And we have a statistician, and she says, based on the request we're making, that she would be able to analyze it and tell us whether he got charged. And we know about other cases where they were white and they were not charged with special circumstances, so because the special circumstances is what means death or life without the possibility of parole. So that's our discovery motion. But then our other motion, which in certain ways I think is a more potent motion, has two parts to it. The first part is the fact that they kicked off the only Indian juror for his second trial, and she answered the questions very favorably toward the prosecution, saying that yes, she would vote for death if she thought that was right. So there are many reasons why she should have been kept on the jury, and instead they kicked her off. So that's one. And then two, as I was researching all this and looked through things that we haven't thought about in a while, I looked at the penalty phase of the second trial, and his lawyer, who had, fell down totally on the job in the guilt and penalty phases, elicited testimony about the conditions on the local reservation that Chief was from, saying that all the young people did drugs and alcohol and, basically were ne'er do wells. They didn't go to school and so on and so forth. And so then he used that in his closing argument, and then so did the DA use that in his closing argument. So, if that's not racist against Native Americans, I don't know what is, because, people are going to hear that, and in their minds, that justifies giving somebody death, because, why keep them around if they're, no good addicts anyway? Um, and the two things also fit together because since they had kicked off the only Indian juror, she was not there to provide any context. So if she had been on the jury and that those things were said, she could have said, "Well, no, this is not universally true," and so on and so forth, and that could have made a big difference in the ultimate result. So for that RJA motion, which is an A1, A2 motion, um, we've asked the court to order an evidentiary hearing, which is what the RJA statute provides for. So those are pending before the court now.
It sounds like the first one is another one that would get it back to a parole situation. Would the second one wipe out the conviction altogether?
It could, it could, yeah. No, that's dismissal is one of the remedies. So yes. And I mean that could be true of the first one as well, because if we can get data and have it analyzed that shows that he was charged more harshly than white people were, that also could lead to a dismissal.
Now, I think from my perspective, watching this thing unfold now for 5 or 6 years, I would argue that the most surprising thing to me is how hard Fresno is fighting to keep this man in prison after all this time. I mean, talk a little bit about who Chief is now, like
Yeah.
what he does, what he is, how old he is, his health problems, all of that.
Okay. All right. Well, he's 66 now. He's going to be 67 next month. And I don't know if most people know, but they cleared out death row in 2024 and sent all of them to other prisons, save for a few. And so he's been at California Men's Colony now for almost a year. It was May 15th of last year. And, when he was on death row, he had asked to be given a job, years ago, because he's the kind of person that likes to be productive, you know. And they never gave him a job. They turned him down. Well, within a short time of getting to CMC is the acronym for California Men's Colony. Getting to CMC, he got a job as a porter, and he's had that job now. And his first review was after 90 days, and he got the highest score possible, and he got a raise from 16 cents an hour to 21 cents an hour. And he enjoys that job. He gets a lot of kudos from the officers and the other prisoners and so on. So he's doing that. And there's just horrible stuff going on at the prisons these days. There's a lot of overdosing, and CDCR is, playing with people's lives the way they do. So he's having to contend with that. Um, but one of the differences is he's able to walk around and not be in cuffs. You know, on death row, they could never, anytime they left their cell, they had to be in cuffs and or waist chains. So that has really been good for him. It's been part of what's hard for me to know is how much has been taken from him. His whole life has been taken from him, and even his childhood was horrific. And notwithstanding that, he still has such a good attitude. You know, he still thinks that it's all going to be made right by him at some point, you know. And he was just saying to me, well, Leonard Peltier just got out. He was down for almost 50. And, basically, I never thought he was going to get out. So he has hope in that regard. And some of the people who have known him over the years, like the rabbi at San Quentin, have said, he's a responsible guy, he's a good guy, he will do well when he's out because he wants to, serve the community and, talk to young people so they don't go down the wrong road and so on. So he has things he wants to do if we can get him out. Good things he wants to do.
I mean, again, I asked the question now that I was starting here, which is basically, Fresno just seems bent on keeping this guy in prison forever, there doesn't seem to be a practical reason to do that.
I can't disagree with you, David. And it's interesting because I listen to a variety of podcasts, and I was listening to a woman who has started getting involved in at least one wrongful conviction case. And her point, she had a couple of points that I thought were valid and apply here. One was that once you persuade people of something, it's very hard to go back on that. So here you have a situation where they persuaded people starting back in 1978 that, Chief was a dangerous killer, serial killer, which was a total lie. And he did this. The victim was white. So, it does have a racial element to it. And so there's a belief in Fresno that he's guilty. And trying to change course on that is very, very hard. So that's one thing. The second thing that she was talking about was how there's the case and then there's the truth. Because the truth is that he didn't do it. The truth is that they framed him and railroaded him by planting the gun and, making a lot of things up, by, discarding evidence, misstoring evidence. It's sometimes it's just so overwhelming to think about all the things they did. And yet, and still, because of our legal system, when you think about the case part of it, a lot of that is not even on the record. Or the things that we could, because some of the things we couldn't get on the record because of the hearsay rules, for example. Or the things that are on the record, as I say, the judge, when he writes his decision, just ignores those or misstates those. So I don't understand why they are so attached to keeping him in there. I really don't. As I say, if we were in some other county, with a different judge, we would have been done already years ago.
Yeah, I
And
definitely agree on that. Um,
yeah.
One thing I think is really important to mention here is like, and those who watch or listen to this podcast regularly know that I am not a conspiracy guy. Like I, I absolutely believe that the simplest explanation is usually the most accurate. However, I will say this about this case is that I am absolutely convinced that when you say evidence was planted, that evidence was planted in this case. It is very compelling. It's overwhelming. To me, the evidence is overwhelming that he didn't do it. I mean, it's one thing for there to be official misconduct in the sense that evidence is buried, or Brady evidence and things like that, which is bad enough. I'm not going to excuse that. That's bad, but actually doing some of the things that I think happened in this case is an order of magnitude worse.
Yeah, I totally agree. And I mean, that's why at the evidentiary hearing, when the county employees got up there, you know, some of them lied. You know, one employee would told one story, and then another employee about the exact same incident told a different story, you know. So, and I mean, the reality is that they all know what's true, and but because they have their own agenda, which is keeping him in. And of course, I think we should not avoid saying that there is a political consequence. So, I mean, when he gets out, um, you know, there's going to be other lawsuits, and they want to do everything they can to try to stave that off, right? So, the longer that, well, and truthfully, I have believed almost since the beginning when I got involved that they have been counting on him dying this whole time. I mean, they figured either he was going to get executed. He had 5 execution dates over the decades. Either he was going to get executed or he would get sick and die in prison. And he did. He got COVID, pre-vaccine, and got quite ill, and arguably has long COVID. He had to have um, stents put in, and that probably was because of COVID. Um, so because they didn't know it in the beginning, but after a while they figured out that it was a heart related disease. So you know there's been many times when he could have died over these decades. And that's saying, also having to survive the prison environment. I mean,
Yeah,
between between solitary confinement, basically being on death row is solitary confinement. And he did that for 46 years. Now, prior or as a part of that, he was also locked in the shoe or the hole or whatever you want to call it for like 20 years. So, most people who were in the shoe for way less time than that basically come out as puddles. There's like nothing, it just totally destroys them. And so that would have been another, you know, reason for him to die, on in one way or another, and he survived that. So I mean, I personally think that part of the reason he's been able to survive and in some ways thrive, really, considering everything, is because he's Native American, you know, because that Constitution is um very powerful and strong, is my observation. So, but yeah, no, I'm sure that they were counting on him being dead, and so he's a problem that just won't go away for them.
amazing story.
Yeah, no, it is. It is. And I mean, it's also, to me, it's really an indictment of our society. I do not know whether in the midst of all the chaos that's going on now, um, we're going to start reassessing things. In my opinion, we certainly desperately need to. But as long as poverty is so widespread in our society, we're going to continue to have the same problem of people committing crime and throwing them in prison because they have no choice. They're desperate. And you take somebody like Chief, who was raised in extreme poverty in an extremely difficult household situation for many reasons, and then ends up at Napa State Hospital where they drug him, and basically confine him there when he was 6 years old. And then, he goes into foster care, he goes into group homes. So, what do we expect when people get to, and then he goes into California Youth Authority? I mean, what do we expect when people are subjected to all that? We think they're going to come out and be, heroes? I don't think so, unless we start addressing that. And I mean, every time they say if they tax the billionaires 1%, it could lift this entire country out of poverty, period. I think, what are we waiting for? I mean, seriously, because that's, in my opinion, that's the cause of a lot of our problems and mass incarceration for sure. So,
Well, I'm with you there. I do want to ask you one more question, and that is, with the governor's term winding down, is commutation an option?
well, we submitted an application for that in April of 2020. We've never heard anything. And so we can certainly add to that, is my understanding. My concern about it is, having been watching what's going on with the Menendez brothers, as well as some other cases, that the governor, excuse me, but is a wuss. He does not want to, he does not want to make this, because he's like, he's got his political future, right?
I only laugh
Um,
because that was my exact word for him a couple of days ago. So,
oh, okay. Yeah, no, because he doesn't want to make any hard decisions about anything. And so, if you look at the Menendez cases, he's shifting that back over to the DA or the court and saying, well, once they make a decision, then I'll look at it again. It's like, no. The whole point is you have the power to look at it now. You don't have to rely on that. But so, is that a possibility? I would not be putting a whole lot of energy on it myself. So,
yeah.
um,
So,
yeah,
so you feel like the resentencing is probably the strongest at this point,
I do, in part because on the Racial Justice Act, I don't know what kind of time element there's going to be in that, you
right?
know. Um, so yeah, I mean, at the moment, yes, I think that's the best. And if it's okay to tell people about our website,
Yes.
um, justiceforchief.org, because we will soon, there's a way to contact me through the website, because we will be soliciting letters to the judge for chief for resentencing. So if people are so inclined to do that, that would be helpful. Or if they want to go to Fresno on May 1st, that'd be another way of showing support. So,
All right. Well, we're going to end it right there. Perfect ending. This is an amazing case, in my view. And I honestly thought it's going to end a year ago, and I should have known better. But
we
um,
all should have.
yes, but I think optimism keeps your soul alive, and so we would die without optimism, and so you just got to be optimistic about these things in the end, even if it breaks your heart.
I agree. I agree.
This has been Everyday Injustice. We've been talking with Alexandra Cock. She has worked her guts out for Chief Stankewitz's freedom, and she will prevail.